Our topic for today is about intellectual property. Intellectual property is a term used to describe works of mind such as arts, books, films, formulas, inventions, music, and processes that are distinct and owned or created by a single person or group. Intellectual property is protected through copyright, patent, and trade secret law. So, ang intellectual property ay isa ka term na gigamit para i-describe ang works of mind, such as art, books, films, formulas, inventions, music, and process that are distinct and owned or created by a single person or group. Also, ang intellectual property is protected siya through copyright, patent, and trade secret laws. Next, copyright law. Copyright law protects authored works such as art, books, film, and music. Patent law protects inventions, and trade secret law helps safeguard information that is critical to an organization's success. Together, copyright, patent, and trade secret legislation form a complex body of law that addresses the ownership of intellectual property. So, ang copyright law, mao ni ang law nga nagprotekta sa mga authored works such as art, books, film, and music. And ang patent law, nagprotekta sab siya sa mga inventions. Also, ang trade secret law is mao sab ni ang law nga nakatabang na pangalagaan ang impormasyong mahalaga sa tagumpay ng isang organisasyon. Next, copyright. A copyright is the exclusive right to distribute, display, perform, or reproduce an original work in copies or to prepare derivative works based on the work. Copyright protection is granted to the creators of original works of authorship in any tangible medium of expression, now known or later developed, from which they can be perceived, reproduced, or otherwise communicated, either directly with the aid of a machine or a device. Ang copyright is mao ni siya ang exclusive right to distribute, display, perform nga kanang kopyahon ang imong original work mo na gitawag nga copyright. So, ang kanang example sa copyright is mao ang books, poems, plays, films, and artwork. Copyright infringement. Copyright infringement is a violation of the rights secured by owner of copyright. Infringement occurs when someone copies a substantial and material part of another's copyright work without permission. The courts have a wide range of their discretion in awarding damages from $200 for innocent infringement to $100,000 for willful infringement. So, ang copyright infringement is mao ni ang violation of the rights nga gisecure by the owner of a copyright. Infringement occurs or kanang infringement is nahitabo siya sa kanang sitwasyon nga kanang naay nangupya og work sa uban bitaw nga walay pananghid. Nag-ingon nga copyright infringement. Eligible works. The types of work that can be copyright include architecture, art, audiovisual works, choreography, drama, graphics, literature, motion pictures, music, pantomimes, pictures, sculptures, sound recordings, and other intellectual works as described in Title 17 of the U.S. U.S. Code. To be eligible for a copyright, a work must fall within one of the preceding categories and it must be original. For example, former Beatles member George Harrison was entangled for decades in litigation over similarities between his hit My Sweet Lord, released in 1970, and his So Fine, composed by Ronald Mack and recorded by the Chiffons in 1962.1. So, ang eligible works is maon siya ang types of work nga mga makopyright such as architecture, art, audiovisual works, choreography, drama, graphics, literature, motion pictures, pantomimes, pictures, sculptures, sound recordings, and other intellectual works. Copyright term. The Copyright Term Extension Act, also known as the Sonny-Bonie Copyright Term Extension Act. After the legislator and former singer-entertainer who was one of the co-sponsors of the bill in the House of Representatives signed into law in 1998 established the following time limits. So, ang copyright term ay ginatawag siya og Sonny-Bonie Copyright Term Extension Act. So, after the legislator and former singer-entertainer na isa sa mga co-sponsors of the bill in the House of Representatives nga nilagdaan nga mahimong batas noong 1998. Nga mahimo siyang law in 1998. So, establish the following time limits. For works created after January 1, 1978, copyright protection endures for the life of the author plus 70 years. So, for works created after January 1, ang protection sa copyright is kanang tumatagal siya for the life of the authors lang plus 70 years. For works created are still original pa rin or renewable term of copyright. For works created before 1978 are still in the original or renewable term of copyright. So, the total term was extended to 95 years from the date copyright was originally secured. Fair use doctrine. Copyright law tries to strike a balance between protecting an author's rights and enabling public access to copyright works. The fair use doctrine was developed over the years as courts worked to maintain that balance. So, ang fair use doctrine is copyright law tries to strike a balance nga magkaroon ng balanse between sa karapatan sa isang author at pagpapagana ng publikong access sa mga naka-copyright na works. So, ang fair use doctrine is na-develop siya over the years habang ang korte ay nagtatrabaho para mapanatili ang balansing iyon. Itinatag ng Title 17 Section 107 ng US Code na dapat i-consider ng hukuman ang 4 factors kapag nag-decide kung ang isang particular na paggamit ng copyright is fair, ang maaaring payagan na walang penalty. So, the purpose and character of the use such as commercial use or non-profit education purposes. Second, the nature of the copyright work. Third is the portion of the copyright work used in relation to the work as a whole, the effect of the use and the value of copyright work. Software copyright protection. The use of copyright to protect computer software raises many complicated issues of interpretation. For example, a software manufacturer can observe the operation of competitors' copyright program and then create a program that accomplishes the same result and performs in the same manner. So, ang software copyright protection is siya ang the use of copyrights para protektahan ang computer software ay nagpataas ng maraming komplikadong issue ng interpretasyon. So for example, is giobserbahan ng isang manufacturer ng software ang kanang pagpapatakbo ng mga copyright na programa ng isang kompetensya. So may balan o kanang makita nila kung unsa nga copyright program ang nabuhat sa ilang kakompetensya. Then paguman is magbuhat sila isa ka program nga pareho ang resulta o pareho sab ang paraan. So, para mapatunayan nila ang paglabag, ang copyright holder is dapat magpakita og kanang kapansin-pansin o kanang kapareho sa ilang software nga ilang ma-explain ang pagkopya nila sa pareho nga paraan. Kopya nila sa pareho nga paraan. Next. The Prioritizing Resources and Organization for Intellectual Property or Pro-IP Act of 2008. The Prioritizing Resources and Organization of Intellectual Property or Pro-IP Act of 2008 increased trademark and copyright enforcement and substantially increased penalties for infringement. For example, the penalty for infringement of a song of a 10-song album was raised from $7,500 to $1.5 million. So, ang Prioritizing Resources and Organization for the Intellectual Property Act o Pro-IP Act of 2008 is mao ni nga act ang nagpataas sa trademark and ang copyright enforcement at pinataas ang mga parusa sa paglabag. Example, the penalty for infringement sa isang album na may 10 kanta ay tinaas mula sa $7,500 hanggang $1.5 million. General Agreement on Tariffs and Trade, or GATT. The General Agreement on Tariffs and Trade was a multilateral agreement governing international trade. There were several rounds of negotiations addressing various trade issues. The Uruguay round, complete in December 1993, resulted in a trade agreement among 117 countries. So, ang General Agreement on Tariffs and Trade ay isa ka multilateral agreement governing international trade. May mga ilang rounds ng negosasyon na tumugon sa iba't ibang mga isyu sa kalakalan. So, ang Uruguay round na natapos noong December 1993 ay nagresulta sa isa ka kasunduan sa kalakalan o trademark agreement among 117 countries. Next. The WTO and the WTO TRIPS Agreement, or the World Trade Organization, is a global organization that deals with rules of international trade based on World Trade Organization agreements that are negotiated and signed by representatives of the world trading nation. So, ang World Trade Organization ay isa ka global organization na tumatalakay sa mga rules of international trade based on WTO or World Trade Organization agreements and signed by representatives of the trading nations. The World Intellectual Property Organization or WIPO Copyright Treaty 1996. The World Intellectual Property Organization or WIPO, headquartered in Geneva, Switzerland, is an agency of the United Nations established in 1967. WIPO is dedicated to the use of intellectual property as a means to stimulate innovations and creativity. It has 185 member nations and administers 25 international treaties. So, the World Intellectual Property Organization na headquartered sa Geneva, Switzerland ay isa ka ahensya ng United Nations na itinatag noong 1967. So, ang WIPO o World Intellectual Property Organization ay dedicated sa paggamit ng intellectual property na isa ka paraan upang pasiglahin ang innovation and creativity or to stimulate innovation and creativity. Next. The Digital Millennium Copyright Act 1998. The Digital Millennium Copyright Act or DMCA was signed into law in 1998 and implements two 1996 WIPO treaties, the WIPO Copyright Treaty and the WIPO Performances and Phonograms Treaty. The act is divided into the following 5 sections. So, ang the Digital Millennium Copyright Act or DMCA ay designan siya nga bilang isang batas noong 1998 and ipinatupad ang 1996 WIPO treaties or duha ka World Intellectual Property Organization treaties, which is the WIPO Copyright Treaty and the WIPO Performances and Phonograms Treaty. Also, the act is divided into following 5 sections. So, first is Title 1, WIPO Copyright and Performances and Phonograms Treaties Implementation Act of 1998. This section implements the WIPO treaties by making certain technical amendments to US. Second, Title 2, Online Copyright Infringement Liability Limitations Act. This section enables website operators that allow users to post content on their website, music, video, and pictures to avoid copyright infringement liability if certain safe harbor provisions are followed. Title 3, Computer Maintenance Competition Assurance Act. This section permits the owner of a computer program in the course of maintaining or repairing the computer. Title 4, Miscellaneous Provisions. This section add language to the Copyright Act confirming the Copyright Office Authority to continue to perform the policy and international functions the policy and the international that is carried out of the decades under its existing general authority. Title 5, Vessel Hull Design Protection Act. This section creates a new form of protection for the original design of vessel hulls. Next. Patents. A patent is a grant of a property right issued by the United States Patent and Trademark Office or USPTO to an inventor, A patent permits its owner to exclude the public from making, using, or selling protected invention, and it allows for legal action against violators. Unlike a copyright, a patent prevents independent creation as well as copying. So, ang patent is isa ka pagbibigay ng property right o karapatan ng ari-arian na inisyu ng United States Patent and Trademark Office sa isa ka inventor. So, ang patent permits is nagpahintulot sa tag-iya o sa may-ari nga i-exclude sa public ang paggawa, paggamit o pagbinta ng protektadong invention, and naghatag ni siya og sakto nga paraan para sa legal na aksyon. Unlike sa copyright nga gi-prevent pa sa patent ang ilang independent creation pati na sab ang pagkopya. Patent infringement. Patent infringement or the violation of the rights secured by the owner of a patent occurs when someone makes unauthorized use of another's patent. Unlike copyright infringement, there is no specified limit to the monetary penalty if patent infringement is found. In fact, if a court determines that the infringement is intentional, it can award up to 3 times the amount of the damage claimed by the patent holder. So, ang patent infringement is nahitabo ni siya. Example, kung naisa ka tao nga nigamit na hindi autorisadong paggamit ng patent ng iba. So, unlike sa copyright infringement, walay gitukoy nga limitasyon sa monetary penalty kung naay nakita nga paglabag sa patent. Next. Leahy-Smith-America Invents Act 2011. The Leahy-Smith-America Invents Act represents a major change in U.S. patent law. Under this law, which was passed in 2011, the U.S. patent system changed from a first to a first inventor to file system effective March 16, 2013. That means if two people file for a patent application in the same inventions at approximately the same time, the first person to file with the USPTO will receive the patent, not necessarily the person who actually invented the item first. So, ang Leahy-Smith-America Inventions Act 2011 is mao ni siya nga act ang nagrepresents sa malaking pagbabago sa batas ng patent ng US. Sa sulod ani nga batas na ipinasa noong 2011, ang sistema ng patent ay nabago mula sa isang first to invent na nabago mula sa first to invent padulong sa isang first to inventor to file system effective March 16, 2013. Next, software patents. A software patent claims as its invention some feature or process embodied in instructions executed by a computer. The courts and the USPTO have changed their attitude and opinions on the patenting of software over the years. Prior to 1981, the courts regularly turned down requests for such patents, giving the impression that software could not be patented. So, ang software patents is ang nag-aangkin bilang invento o proseso nga isinagawa sa isang computer. So, ang mga korte at ang USPTO ay nabag-o ang ilang attitudes and opinions on the patenting of software over the years. So, prior to 1981, ang korte is regularly turned down requests for such patents na naghatag og impression na ang software could ang katag ang impression na ang software could not be patented. Ang software could not be patented. Next, cross-licensing agreements. Many large software companies have cross-licensing agreements in which each party agrees not to sue the other over patent infringement. So, ang licensing agreements, so it means daghang mga dagko nga company sa software nga naa sila'y kasunduan about cross-licensing agreements in which party or partido ay kanang sumasang-ayon nga dili idemanda ang isa sa mga patent infringement. So for example, naglaban ang Apple and HTC sa mga sa nagkalahi-lahi nga patent but related ra gyapon siya sa mobile phone, which is eventually lead nga giban sa US International Trade Committee sa pag-import sa duha ka modelo ng HTC mobile phone. Next, trade secrets. Trade secret was defined a business information that represents something economic value, has required effort or cost to develop, has some degree of uniqueness or novelty, is generally unknown to the public, and is kept confidential. So, ang trade secrets was defined as business information nga nag-represent sa economic value. There is some degree of uniqueness or novelty which is unknown to the public nga nagpabilin gihapon nga confidential. Nagsugod ang trade secret protection sa pag-identify sa tanan nga impormasyon nga dapat protektahan gikan sa walay gipakita o gilantad nga kanang patent application hangtod sa market research and business plan nga magpabilin nga secure ang information. Next, trade secret laws. Trade secret protection law vary greatly from country to country. So, ang trade secret law is mao ni nga ang nag-imposes og mga penalties or kanang nagpatong og penalties up to $10 million and 15 years in prison para sa thief of trade secrets. Next, the Economic Espionage Act or EEA 1996. The Economic Espionage Act or EEA of 1996 imposes penalties of there was no specific criminal statute to help pursue economic espionage. The FBI was investigating nearly 800 such as cases in 23 countries when EA was enacted. So, employees and trade secrets. Employees and the greatest threat to the loss of company trade secrets. They might accidentally disclose trade secrets or steal them for monetary gain. Organization must educate employees about the importance of maintaining the secrecy of corporate information. So, ang employees and trade secrets, so it means nga ng mga employees daw the greatest threat the loss of company trades. So para kanang balikay sa ingon ana nga sitwasyon is dapat nga i-educate sa mga organization ang mga employees about the importance of maintaining the secrecy of corporate information.
K. Intellectual property issues. This section discusses several issues that apply to intellectual property and information technology, including plagiarism, reverse engineering, open source code, competitive intelligence, trademark infringement, and cyber squatting. The first is plagiarism. Plagiarism is the act of stealing someone's idea or words and passing them as of one's own. The explosion of electronic content and the growth of the web have made it easy to cut and paste paragraphs into terms papers and other documents without proper citation or quotation mark. To compound the problem, hundreds of online paper mills enables user to download entire term papers, although some sites post warnings that their services should be used for research purpose only. Many users face can't hit. So, plagiarism dili lang ni siya sa research nga na, kundi para sa bisag asa gini makita. Pwede sab ni siya sa kanang playwrights, sa musicians, journalists, and even sa software developers. Then plagiarism is the act of stealing someone's idea. So gingon na gani nga mangawat og ideya sa source, gikan gyud sa source. So mo na tawag nga plagiarism, like kanang sa mga musicians na sa kanang ilahang mga tugtog gani sa kuan, gitawag gyapon na siya nga plagiarism. So next is reverse engineering. Reverse engineering is the process of taking something apart in order to understand it, build a copy of it, or improve it. Reverse engineering was originally applied to computer hardware but is now commonly applied to software as well. Reverse engineering of software involves analyzing it to create a new applied to software as well. Reverse engineering of software involves to create a new representation of the system in a different form or at a higher level of abstraction. Often, reverse engineering begins by extracting design stage details from program code. So, ang reverse engineering is kanang kibali magpalit ka og magpalit kag machine. Imuhang bungkagon tapos imuhang i-disassemble tapos imong i-assemble og balik. Tapos muro siya og kanang kung pangitanim mo kanang pamaagi para mo improve gani ang machine, para malabwan pud nimo ang katong gikan sa imong gipalitan. So mo nay reverse engineering. So ang one of the best example ani is when a new machine comes to market. Mo na akong gingon, competing manufacturers may buy one machine and disassemble it to learn how it was built and how it works. A chemical company may use reverse engineering to defeat a patent on a competitor's manufacturing process. So, mo na gito akong gingon nga kibali ko magpalit kag machine gikan sa market. Tapos imuhang siyang bungkagon, tapos murag imuhang siyang i-improvise ba nya giun siya sa pagka lihok sa machine, tapos mo nang imuhang i-improve para malabwan ang katong imuhang gipalitan asa gikan sa manufacturer process. Motoy reverse engineering. So next is open source code. The makers of proprietary software have not made their source code available, but not all developers share that philosophy. Open source code is any program whose source code is made available for use or modification. As users or other developers see fit, the basic premise behind the open source code is that when many programmers can read, redistribute, and modifies a program's code, the software improves. Programs with open source code can be adapted to meet new needs, and bugs can be rapidly identified and fixed. Open source code advocates believe that this process produces better software than the traditional closed model. So ang open source code is like kanang sa website, 'di ba? Pag nakay research mag-research ka, nakay pangitaon. So adto ka sa Google, pag research nimo, pag open ang example aning open source code is kanang direct na gani nga ma-open nimo ang mga information nga gikan imong i-research sa Google, like Wikipedia, di ba? Pag click nimo sa Wikipedia, mo-open din nimo. That's we call open source code, kay wala gani siya kuti, diretso ra. Ang open source code is, ang mga example ana is Wikipedia, kanang Brainly, kana ang mga uban pa, daghan mga klase. Kanang Mozilla Firefox, na tara maka kuan pud ka. Then ang open source code is licensed na siya nga pwede sa tanan, bisan pag kanang need jud nimo nga panghinanglan na gyud kay makuha kay open source code man. Then ang nakanindot po sa open source code is dili naka maglisod, kay naman gyud dito tanan ang information nga imong research. Tapos kaysa sa closed model, ang closed model is siya kanang like naay password gani, mag-password pa ka, maggamit pa ka og account nimo, mag-sign up pa ka, mo na yung mga closed model. So ang example sa open source code is BSD license, GNU General Public License, GNU Lesser General Public License, MIT License, Eclipse Public License, and Mozilla. Muna siya. Muna sa mga example sa open source code, ug daghan pa. The next is competitive intelligence. Competitive intelligence is legally obtained information that is gathered to help a company gain an advantage over its rival. So for example, some companies have employees who monitor the public announcement of property transfers to detect any plant or store expansions of competitors. An effective competitive intelligence programs require the continual gathering, analysis, and evaluation of data with controlled dissemination of useful information to decision makers. So ang competitive intelligence is nagkuan siya, naglakip sa mga negosyante sa stock nga mag-analyze gani, tapos unsaon ang paglihok sa proseso aron mahibalan ang pinakamaayo nga pamuhunan nimo, o para malabwan nimo ang imuhang ka-compete. Then syempre lahi-lahi ta og kanang analysis, lahi-lahi ta og gathering. So dito kita mangita sa kanang gagmay og gagmay gani og pangayo para pag abot sa imuha daw ka ginansya. Like pag mangumpra ka dapat mangita jud kag mas barato pa gyud para pag abot sa imuha dako imuhang ginansya, dili ka malugi. So daghan klase nga pag gathering sa data. So mo na competitive intelligence. Then next is trademark infringement. A trademark is a logo, package, design, phrase, sound, or word that enables a consumer to differentiate one company's products from another's. Consumers often cannot examine goods or service to determine their quality or source. So instead, they rely on the labels attached to the products. So, ang trademark infringement nagpasabot nga ang usa ka marka sa logo dili kanang mauna lang gani ang gisaligan sa mga consumer kay para wala na sila nag-base sa dili nila mahibalan ang quality gani. So munang dito lang sila nag-base sa logo. For example is kanang Lacoste nga brand. So di ba pag makita na to nga ang ingana ayang brand Lacoste, so mainganyo rin ta nga nindot lagi ni ana, pero wala kabalo ang mupalit nga ang katuday is kuan lang siya kanang class A ingana, dili siya original kay wala man ta kabalo nga kuan. So sa ngalan sa brand label man nagbasis na lang man ang mga mupalitay. So mo na ang trademark infringement. Issue po ni siya kay kanang murag gi-fake nila ang mga tao. Murag blind lang ang mga tao ba. So mo na nga nagsalig sila sa mga label para dako ilahang ginansya sa mamaligya ay. Mo na yung trademark infringement. Then last is cyber squatting. Companies that want to establish an online presence know that the best way to capitalize on the strengths of their brand names and trademarks is to make the names part of the domain names for their websites. When websites were first established, there was no procedure for validating legitimacy of requests for websites names, which were given out of first come first served basis. And in the early days of the web, many cyber squatters registered domain names for famous trademarks or company names to which they had no connection, with the hope that the trademark's owner would eventually buy the domain name for a large sum of money. So ang cyber squatting is online siya, online basis. Website siya ang gamit ani nga para mahibalaan nga labing kaayo ang paagi, mapahimuslan ang kusog sa ilang mga ngalan sa tatak sa mga marka sa pamatig-ayon. Ang paghimo ani is bahin sa mga ngalan sa domain, mga famous nga mga trademarks or company names. So syempre kita nga mga maingganyo is mo register gud ta kay wala man ta kabalo. So mo nang daghan po nainganyo ani para marehistro ilang ngalan dito sa kato nga website. Then paghuman sa katapusan mopalit sa domain name alang sa usa ka dako nga kantidad sa lapi. So mo to siya cyber squatting. Thank you.